Does Canada have a constitution? Well, the short answer is yes. In fact, upon its face, Canada technically has two constitutions. The Constitution Acts 1867 to 1982. The pluralizing of the word acts implies the existence of two constitutions. However, to understand Canada's constitution, one should start at the beginning. Originally known as the British North American Act, in 1982, it was renamed the Constitution Act 1867. The Constitution Act is an agreement. So who is this agreement between? Well, let's look at the preamble. The beginning of the first paragraph of the preamble, it states, whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire to be federally united into one Dominion under the Crown. This statement identifies the subjects of the agreement. The subjects are the provinces of Canada, which would be Upper and Lower Canada, Nova Scotia, and New Brunswick, and the Crown. So who are these provinces? Well, the provinces would be the elected representative governments of the day. These men were the elected representative governments of the day and are also known as the Fathers of Confederation. And they represented the people of the provinces. In essence, these governments of the people, by the people, and for the people of the provinces entered into an agreement on behalf of the people of these provinces. And they entered into the agreement with the Crown. While most Canadians are ignorant of its existence, this agreement does create and establish governments of Canada. However, if you stop looking at it from the micro perspective, you come to realize the nature and spirit of this agreement. You'll realize it is the creation and establishment of the justice system of Canada, created and established in part by the people, of the people, and for the people. It is the established template of how law and order is to be created and judged in Canada. In the first part, the left side of the scale, the governments which are created and established are so established to create law. These governments include, but are not limited to, the Crown, the Executive Council, the Legislative Assembly of the Parliament of Canada, and the Executive Councils and Legislative Assemblies of the Provincial Parliaments of Canada in right of the province. Together, these characters of governments created and established were so established to bring forth law in Canada. These governments are the legislatures. Why create law? As mentioned in my needs video, law is created in order for the people to live harmoniously together in society, and in particular, a free society, the nation of Canada. And these governments of Canada, so established in the first 5 parts of this agreement, by this agreement, have the authority to create law of Canada. But where there is law, order should follow. The judicature under Part 7 brings forth order, and the judicature is created and established as an independent, separate branch of government. In fact, the judiciary is recognized and acknowledged as an independent, separate branch of government. Together, the legislatures and the judicature create Canada's justice system, and when they work in accordance to the provisions set out in the Constitution, the scales of justice are in balance. At issue, it appears sometime in the recent past, I'm not sure, maybe about 40 or more years ago, the Ontario Court of Justice was separated, with one half presiding over minor penal summary offences under the Criminal Code, and the other half even more minor offences under the Provincial Offences Act. At further issue, justices of the peace were granted authority to permissively preside over the Ontario Court of Justice and the Provincial Offences Act. Why is it an issue for a justice of the peace to preside? Because this creature is not founded in the judicature with the Minister of Justice presiding. It is of this issue that justices of the peace permissively preside, because they have not been constitutionally bound by agreement with the Minister of Justice of Canada. It is why their presiding nature is permissive. Those not bound by agreement with the minister to preside need to be bound by agreement elsewhere, which is how they ambiguously trick you. In Ontario, judges are bound by agreement under Section 151.1 Courts of Justice Act. Absent from that agreement are justices of the peace, and further lends the appearance of their nature of authority as permissive. And as it previously mentioned, this permissive nature is recognized and acknowledged under Section 39, Subsection 2, Courts of Justice Act. Why does this matter? Because in the last several years, honest, hard-working Canadians have been brought before the Ontario Court of Justice Provincial Division for reasons like trying to make a living and opening their business in order to earn that living. Removal of the inherent jurisdiction of the lowest level of court and tribunals causes an imbalance to the scales of justice. The nature of that imbalance is that the creature, known as Justice of the Peace, is in the legislative government under the Lieutenant Governor and not in the judicature under the Minister of Justice, as it should be. All law of Canada should be both constitutionally created and judged. And where there exists fewer constitutionally bound courts or courts with inherent jurisdiction, the requirement for the creation of law to comply to the provisions set out in the Constitution and the judicature is greatly reduced, and the scales are tipped. The tipping of the scales allows individuals, not of the people, to influence the creation of laws in a manner that infringes, abrogates, or abridges the people's individual rights and freedoms. The tipping of these scales allows tyranny to rule. In absence of justices of the peace being constitutionally bound, the Ontario Court of Justice Provincial Division lacks inherent jurisdiction, causing it to be inconsistent with the provisions set out in the Constitution, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Unless the litigant brings forth a constitutional argument that establishes the point or points of inconsistency and follows with an argument which proves that point and establishes that point as the error in law, no higher court can cure the defect, because the courts of inherent jurisdiction can only work with the argument and evidence presented before them with respect to the established error in law. Now you know.